Okay, hello and welcome everybody. My name is Polly Rodway and I'm a partner here at BDBF. I'm joined today by my colleague Theo Niku, who is a senior associate in our team. And we're also joined by our principal knowledge lawyer, Amanda Stedman, who's helping us out with the slides and is going to facilitate a Q&A at the end. So what are we going to cover today? So as you know, we're here to talk to you as employers about the niggly subject of dismissing employees who have difficult working relationships. And we've called this webinar Square Peg in a Round Hole, because I think probably we can all relate to people we would describe that way. Someone who's perhaps perceived as difficult, who rubs people up the wrong way, and for whom working relationships are difficult. Now, employers may well be prepared to put up with that, and I would suggest that they should be prepared to be putting up with that, as long as the person is doing the job well and the disruption isn't too severe. In this session, we're thinking about where that's no longer the case. So the relationship with an employee has deteriorated to such a point that differences seem to be irreconcilable, where personality clashes perhaps have caused friction, upset, and a disharmony at work, and you've got to the point where that just can't continue anymore. Now, sometimes I would suggest that an employee's actions in this sort of scenario might clearly amount to misconduct, justifying disciplinary action. So, for example, if an employee has been aggressive or abusive towards a colleague. But what about the cases that are less clear-cut, where perhaps an employee's challenging behaviour has set the ball rolling on problems with colleagues, but it's difficult to pinpoint specific misconduct which would justify dismissal? Nevertheless, you as the employer have a sort of unsustainable situation. So a few examples here. So what about if you have an employee who has a communication style that's alienated colleagues or perhaps even third parties over time? They might double down when faced with criticism, and you might have got to the point where you think they're not going to change and this situation can't continue. You might have an employee who antagonises and criticises colleagues, perhaps not always to their face, and close colleagues have got to the point where they just don't want to work with this individual anymore. Or you may have a junior employee who's turned against their manager and is generally disrespectful, uncooperative, and that in turn negatively impacts the delivery of important work. It's these types of situations that we're really talking about today. And I want to bring alive the point that dismissal for SOSR grounds, which we're going to unpack significantly through this session, might come to the rescue, as you may be able to fairly dismiss an employee relying on that as your justification. So on the slide here, we've outlined the sections we're going to cover. And at a very sort of high level, what we're going to do is sort of start with legal principles, bringing through some practical tips as we go through, but round up those practical tips at the end. We're planning to speak for about 50 minutes, and after that, there will be some optional time for questions and answers. Now, because we're presenting in webinar format today, the most straightforward way to ask a question, if you have one, is to put it in the Q&A box. You can ask them anonymously if you wish. Finally, we are recording today's session and we'll circulate the recording after we've finished, but we won't be recording the Q&A bit at the end. So without further ado, let's get started in the sort of substance of today's session. And I want to start with a recap of what it means to dismiss for some other substantial reason. And this is because, as I sort of suggested in the introduction just now, this is probably going to be the potentially fair reason you would seek to rely on to justify the dismissal if you have a relationship breakdown or personality clash type dismissal. So what exactly is some other substantial reason? What are we talking about here? So, as I'm sure you all know, there are 5 potentially fair reasons for dismissal set out in Section 98 of the Employment Rights Act. Now, the implications of dismissing someone outside of these 5 reasons, or indeed within the reasons but still unfairly, is a claim in the Employment Tribunal for unfair dismissal. And of course, there's always potential for other more serious claims too. Now, we know that a straightforward unfair dismissal claim currently has a value of the lesser of a year's pay or a statutory cap, and that statutory cap at present is around £115,000. It's worth noting that the cap is something that the Labour Party has indicated it may seek to remove if it comes into power. But for now, let's work with what we've got. So if an employer wishes or intends to fairly dismiss an employee and mitigate against the risk of an unfair dismissal claim, you're going to be focused on establishing that your reason for dismissal falls within one or more of these potentially fair 5 reasons. And within those 5, you've got 4 reasons that are sort of specific reasons. So you have conduct, capability, which includes both performance and ill health, redundancy, and illegality. The 5th reason, which is sort of set out as an alternative, as you can see from the word or that we've highlighted in section 98 on the slide here, is where there is some other substantial reason to justify dismissal. And this is what's colloquially known as an SOSR dismissal. At a high level, dismissal for SOSR can be understood as a sort of residual catch-all, potentially fair reason for dismissal. And that means that in practice, employers seek to label all sorts of things as being some other substantial reason. And one that we see often is relationship breakdowns or personality clashes. Now, in practice, the reason for a particular dismissal may not fall neatly into just one category. There may be overlapping reasons, and in an SOSR type scenario, I would say that's probably quite likely. In a relationship breakdown case, I would say the overlapping reason is usually conduct. So, for example, the employee's difficult behaviour may have been the catalyst for the problems at work, and that individual therefore bears responsibility for their behaviour. Indeed, as I said, there may be clear-cut cases where you feel that the behaviour itself is serious enough to amount to something like bullying, harassment, perhaps insubordination, which justifies approaching all of this as misconduct. In other cases, though, it is less clear-cut, as I've sort of interluded. And the key question for you as the employer is to apply your mind as to exactly why it is that you are dismissing. Is it the employee's behaviour, which would be conduct? Or is it the intolerable outcome of a behaviour, which I think is better understood as SOSR? Now, we think you will all be well familiar with how to handle disciplinary matters and dismissals for misconduct. So today we're looking at that lesser known side of the coin. So when will a relationship breakdown qualify as some other substantial reason? And how do you dismiss fairly where you feel this is the reason? So let's start then with thinking about whether the breakdown of a working relationship is potentially a fair, substantial reason within that category. And I think I've probably already given you a bit of a spoiler on this, that potentially it is, but subject to various thresholds. So let's unpack that a bit. Although there's no statutory definition of the term some other substantial reason, we know from case law that any reason, however obscure, may qualify as a substantial reason. That said, the reason must be substantial. We know that, it's in the law, and we now know that that means it must not be whimsical or trivial. In a relationship breakdown case, we would suggest that the relationship breakdown will only be considered to be substantial if that relationship has deteriorated to such an extent that the employee cannot be retained without causing unacceptable disruption. So in other words, a lesser sanction, such as redeployment, won't be appropriate. The reason must also not be rooted in an unlawful reason, by which we mean it mustn't be discriminatory or in response to a protected disclosure, colloquially known as blowing the whistle. For this reason, before considering dismissal down this path, you as the employer need to interrogate the reasons that lie behind the relationship breakdown in order to discount the risk of a prohibited reason being at play. And I'm going to unpack that significantly later on in our section on red flags. The burden is on you, the employer, to show that the relationship breakdown amounted to a substantial reason and that it was the sole or principal reason for the dismissal. So if you're going to go down this path, you need to be prepared to be scrutinised on that. Lastly, I want to say that establishing that a relationship breakdown is a substantial reason for dismissal, of course, isn't the end of the story. To show that a dismissal is fair, you as the employer also have to convince a tribunal, if it gets to litigation, that your decision was reasonable in all of the circumstances, taking into account the size of your business, the administrative resources available, general principles of equity, and the substantial merits of the case. What this is going to come down to is showing that you followed a fair process prior to dismissal and that your decision fell within a reasonable band of responses available to an employer in those circumstances. So without further ado, let's kind of get into a little bit more depth at when difficult working relationships might satisfy this substantial threshold. And Theo is going to talk us through with some real life examples to help us understand it a bit better.
Thanks, Polly. So when might the existence of a difficult working relationship qualify as a substantial reason? Broadly, there are three ways it will arise. Firstly, the employee's difficult personality causes a serious breakdown of working relationships with colleagues. Secondly, the employer loses trust and confidence in the employee due to their behaviour. And thirdly, a third party pressures the employer to dismiss an employee following the breakdown of a relationship between that third party and the employee. I'm going to look at these in turn, providing examples from real life cases. I'll be addressing these at high level, but please do get in contact if you'd like further detail on the cases mentioned. I'll then round up the key points. Beginning with type 1, an employee's insensitive approach that causes a bad atmosphere, for example, talking frankly about their sex life at work, could potentially result in a dismissal for some other substantial reason if it had a serious impact on the business. So could a determined and forceful personality that leads to complaints and disharmony from other staff members. Similarly, an employer's brusque manner that leads to a breakdown in the functioning in an employer's operation, perhaps due to their management style, could be some other substantial reason. In the case of Perkin and St George's Healthcare, Mr. Perkin was a finance director of an NHS trust and was responsible for managing a team of employees, liaising with senior colleagues, and establishing working relationships with third parties. His manner and management style led to a breakdown in working relationships with other members of the senior executive committee and meant that he failed to establish the necessary relationships with relevant stakeholders and third parties. Mr. Perkin claimed he had effectively been dismissed because of his personality and that this was unfair. The Court of Appeal agreed that an employee's difficult personality per se could not amount to a substantial reason capable of justifying dismissal. However, the manifestation of that difficult personality could do so. Looking at the second row of the grid, blunt and antagonistic behaviour, to the extent it leads other employees to submit formal complaints or threaten to resign, could be some other substantial reason to dismiss, as this could demonstrate a fundamental and irretrievable breakdown of trust between colleagues. A relationship breakdown between staff that emanates from a lack of respect, perhaps following the refusal of a pay rise, if it disrupted the wider team in a meaningful way or at a business critical time, could also qualify. However, the tribunal is likely to be on high alert where a junior employee is dismissed due to a relationship breakdown with a senior member of staff, as they'll be alive to the fact that it may be cover for the real reason. It's not enough for the employee not to be a good fit. Finally, an employee who struggles to accept change and becomes a destabilizing force could cause a relationship breakdown that potentially justifies dismissal. Our firm had a case where an inventor and former CEO who remained a director and employee of the company was deemed to be destructive and showed no willingness to change, leading to a breakdown in the relationship with the new CEO. His dismissal was deemed to have been fair despite not being given a right of appeal, and that's quite rare. What's clear from these examples is that while the ways in which difficult personalities can cause relationship breakdowns can vary, the bar is quite high, and the tribunal will look at the consequences of the employee's actions on the business. Moving on now to the second type, which is the employer's loss of trust and confidence in the employee. This is less common, and generally, the tribunal doesn't love employers taking this approach. However, there are some examples of cases where it has been successfully argued. In the context of a disabled man who employed a carer, where they had a series of minor disagreements that were not considered to be trivial in the context of that relationship. And in another case, a serious personal attack on the integrity of the CEO caused a relationship to be beyond repair. I briefly mentioned that the tribunal is wise to SOSR being used as cover for the real reason. In one case of a dispute over an entitlement to shares, an employer dismissed an employee citing a loss of trust and confidence and the relationship being unworkable. But this was after the employee had communicated that he was beginning to lose trust and confidence in the company. The tribunal determined that the power struggle was the real reason, as it was clear that the parties could still work together even though the relationship had soured. It's more helpful, therefore, to focus on the specific issue that led to the dismissal, i.e., is misconduct the real reason? The tribunal has said citing loss of trust of confidence should not be used as a convenient label to apply in a situation where there is no obvious fair reason for dismissal. Having said that, there is likely no harm raising SOSR in the alternative if the first ground, for example misconduct, is not made out. But you would ideally want to do this from the outset, i.e. in the termination letter. This would help avoid the perception that you're tagging it on after the event in response to a claim. Finally, with regard to the third type, we're talking about a relationship breakdown between an employee and a third party, for example, a supplier or a client of the employer. In such cases, the substantial reason is that the third party has applied pressure to the employer, either to dismiss the employee or face some sort of negative consequence. Dismissal in response to third-party pressure is potentially fair, and the precise details of why the third party has made the request will usually be irrelevant. What is relevant is how important the continued relationship with the third party is to the employer, and how serious and definite the threat by the third party is. By way of example, a security guard came into conflict with a senior council employee and was later dismissed at the behest of the council. In such a case, the tribunal will consider whether the dismissal is an injustice to the employee, taking into account things like length of service, disciplinary record, and where it leaves them in terms of getting another job. If there is an injustice, the employer must be able to show that it has considered what steps it can take to avoid dismissal. For example, could the third party be persuaded to change its mind? Or could the employee be redeployed? Another example is where a bus driver for disabled children was employed by a contractor who deployed him to a council. The council discovered that the employee had been accused of child sex abuse, which he denied and was never charged with, and sought to have him removed. In this case, because the employer had sought to persuade the council to change its mind and had considered alternative roles, the dismissal was held to be fair. So, what are the key takeaways? Dismissal because of an employee's difficult personality alone will not be fair. Given the misgivings expressed over citing loss of trust and confidence as a substantial reason for dismissal, it is preferable to avoid approaching dismissal in this way. Where the SOSR route is pursued, an employee needs to show that the working relationships in question have deteriorated to such an extent that retaining the employee risks an unacceptable level of disruption to the business. Importantly, the fact that an employee is merely regarded by others as awkward or not a good fit or not a team player is unlikely to be sufficiently substantial. Where the SOSR route is pursued, it must also be the case that the working relationships in question have broken down irretrievably. This may be evidenced by employees' colleagues refusing to work alongside them anymore, or by the employer showing no willingness to build bridges, or both. Where a junior employee is to be dismissed because of a breakdown in relations with a more senior employee, be prepared for a greater degree of scrutiny by tribunals into the underlying breakdown to check that there is no hidden reason for dismissal. I'll now pass back to Polly, who's going to talk about some red flag issues.
Thanks, Theo. I feel like the sort of typical lawyer doing the red flag point, but I think it is really important that we pause at this point and do that. So the first sort of red flag I want to talk about is the relationship breakdown really the reason for this dismissal? Is actually the case that someone is relying on that as a cover up for something more sinister? So, for example, is the employee really being dismissed because he or she has a protected characteristic? Or are they being dismissed because they've rejected a colleague's sexual advances? Are they being dismissed because they've committed a protected act? So they've complained about discrimination in the workplace, or perhaps they've blown the whistle on some sort of malpractice. It's really important to consider this question early on, because if the dismissal is found to be for one or more of those prohibited reasons, the dismissal will be automatically unfair or discriminatory. And if that's the case, the potential compensation, as you'll know, is likely to be uncapped, meaning the risk of a claim to the business is much more significant. Depending on the circumstances, any such claim may also attract unwanted negative publicity. And finally, in some of these situations, employees can apply for interim relief. Now, I'm not going to get into the detail of what that means and how it unravels. All you sort of need to know at this point is that it's a step that significantly increases cost, resources, the stakes, if you like, early on, and something you'd prefer to avoid. So what we're really talking about here are what are the motivations behind the decision to dismiss? And I think there's a risk of this getting a bit technical, but I'm going to try and avoid that if I can. So a dismissal on the grounds of a relationship breakdown isn't inherently discriminatory. So on its face, saying it's the relationship breakdown doesn't look to be discriminatory. But a tribunal won't stop there. They'll want to look behind the scenes, behind the decision, to get to the bottom of what motivated the decision to dismiss. So I want to talk for a few moments about whose motivations we're actually talking about. In a discrimination case, the tribunal is going to focus on what was in the mind of the person who made the decision to dismiss, so your dismissing officer. It's not necessary, technically, to consider the motivations of anyone who supplied information to or sought to influence the decision maker. So that means effectively the tribunal doesn't have to get into the detail of what was in the minds or the motives of the people involved in the investigation, or perhaps who made the complaints against a colleague. They're really just thinking about the person who makes the decision to dismiss and whether they are acting with bias on grounds of a protected characteristic. A very similar approach is taken in whistleblowing claims. So here again, a tribunal will look at the reason for dismissal operating on the mind of the decision maker, the dismissal decision maker, or if there is more than one, on their minds. However, the Supreme Court has identified what they called a narrow qualification to this role in the case of the Royal Mail and Duty. And if you're familiar with BDBF webinars, you'll be sort of familiar with this case because it's one that I feel, talk about quite often. What this case established is that in a whistleblowing scenario, an employer can be fixed with the motives of someone other than the official decision maker when dealing with dismissal because someone has blown the whistle, provided that that person with the ulterior motives was senior to the employee being dismissed. So trying to kind of bring that to life for you. So in the case of Duty, the employee had blown the whistle to her manager. It didn't go down well, as is often the case. The manager subsequently constructed a performance issue about Duty, and the employee was facing dismissal on the basis of those concerns that the manager had raised. Now, although that dismissing officer didn't have the full details of the protected disclosure and wasn't themselves motivated by that as the reason for dismissal, because they'd just accepted the manager's performance concerns, when it came to be considered by an employment judge, what happened is that the Royal Mail was fixed by the motives of that more senior manager, the manager who bore the grudge, effectively, because Duty had blown the whistle, and found that that person had sought to cover up the real reason for dismissal by constructing performance concerns. So in other words, that decision and that sort of motive was the one that stuck with the employer in the end. It's not possible for employers to insulate themselves entirely from the risk of a prohibited reason being identified as the real reason for dismissal. But I do think there are some practical steps that employers can take to minimise this risk. First of all, codes of conduct and training should set out the standards expected from managers and should emphasise the importance of honest, ethical, non-discriminatory behaviour in all dealings and the consequences of failure. Decision-making processes should be as transparent as possible, and those providing information or evidence to a decision maker, for example, in an investigation process, should be instructed not to stray into the territory of lobbying for a particular outcome. In the event that a dismissing officer is heavily influenced by someone else when they make their decision, the safest course would be to regard that person as a joint decision maker. Dismissing and investigating officers should receive detailed training on the scope of their role, and that training should underline the importance of looking for and really interrogating evidence that supports the proposed reason for dismissal, as well as any evidence that supports the employee's side of things and what they're putting into the mix in that process. Finally, dismissing officers must satisfy themselves that the apparent reason is the real reason, even if that requires more extensive witness proofing or taking of evidence and reviewing more documentation than they initially planned or desired. It's important to kind of get home the fact that they may well be scrutinised on this decision and to really get to the bottom of making the right decision on the right information at the time. Okay, so that's the first red flag. The second red flag I want to talk about is sort of moving on from the cover-up type scenario and thinking instead about where dismissal may well genuinely be because the relationship has broken down, but the reason the relationship broke down arises from discrimination or a protected disclosure and is sort of inseparable from it. I'm going to talk about three scenarios here. I think the first one is sort of particularly pertinent, which is whistleblowing cases. And I think the reality is whistleblowers often do deliver unwanted messages, which can lead to friction in the workplace, which is why I think it's a live issue sort of here. And I'm going to talk you through a case example to try and bring this to life for you. So this is the first bullet on the slide there. So in the case of Worley and Pinewood Veterinary Practice, Ms. Worley was a veterinary nurse and she blew the whistle about the conduct of a vet who had stood on a dog's neck to restrain it and later sent it home with a limp. Now, relationships between Ms. Worley and the vet in question were already strained, but they deteriorated significantly after this incident. They deteriorated so much that Ms. Worley asked not to work alone with the vet during evening surgeries, and he then went on to make a complaint about her too, saying he could no longer work with her at all. The veterinary practice asked Ms. Worley whether she would work at a different site to kind of alleviate the issue, but she refused on the basis that her nursing duties would be reduced in that other role. Eventually, she was dismissed on SOSR grounds, and the substantial reason given was the relationship breakdown. Now, ultimately, that dismissal was held to be automatically unfair on whistleblowing grounds. Where the tribunal basically got to was that, yes, the relationship had broken down, but the reason the relationship had broken down, and specifically the reason the vet had refused to work with Ms. Worley, couldn't be separated from the fact that she had blown the whistle. So to kind of really simplify it, the employer wasn't dismissing her because she had blown the whistle. That was the real reason. They were dismissing her because of the relationship breakdown, but the reason the relationship had broken down was because she had blown the whistle. Another potential issue of separability arises where the dismissal is closely linked to concerns about health and safety. So, for example, an individual might be particularly zealous about implementing a new health and safety policy. That in turn could easily cause friction, and the result is dismissal for SOSR because of the relationship breakdown. But I can easily see, and there are cases that support this, that could be considered to be inseparable from voicing those health and safety concerns and therefore automatically unfair. So you're in the same sort of situation as Worley. The last bullet on the slide here is something I think that in reality comes up a lot, which is where there is a crossover between behaviours and a potential disability. So we know that where an employee is treated unfavourably for something which has arisen out of their disability, so not because of the disability itself, but because of something that arises out of that disability, that can constitute discrimination arising out of a disability. And I think this is a very live issue when we're talking about relationship breakdown matters. So let's take the example of an employee, excuse me, who is abrasive, unpleasant to colleagues, and that leads to widespread upset and ruptures in working relationships. Now, if the employee can show that their behaviour arose out of a disability and the employer knew or ought to have known about that disability, then any resultant dismissal related to those behaviours could be discriminatory. The reality is that difficult interpersonal behaviour can arise out of all sorts of disabilities, both mental and physical. For example, autism, Asperger's, bipolar disorder, depression, menopausal symptoms, dementia, or even a physical impairment which caused a person to suffer acute pain. It could also be caused by stress, and although stress itself isn't likely to be a disability, you need to be alert to it because it can lead to anxiety and depression, which could be disabilities. This issue arose in the case of Muir and AstraZeneca, which I'm going to talk you through again to sort of bring this point to life. So Dr. Muir suffered from anxiety and depression, and he didn't deal with stress very well. During a particular project, he didn't feel his colleagues were pulling their weight, and this made him feel increasingly stressed. That stress led him to display kind of Jekyll and Hyde type tendencies. He brought sort of difficult behaviour to work. This included poorly worded emails, he raised his voice, and he generally had difficulties working with his colleagues in his team. Although no formal complaints were raised against Dr. Muir, HR did commence a disciplinary process against him, and they concluded that his behaviour was unacceptable. It was considered to be intimidating and amounted to bullying and harassment, for which he was dismissed. Dr. Muir went on to bring discrimination arising from disability and unfair dismissal claims. Now, the tribunal accepted that Dr. Muir was overly forceful in the manner in which he'd expressed himself. However, it found that this was beyond his control and arose as a consequence of his disability. So he got past that first kind of element of the test. Now, with discrimination arising from disability cases, there is a justification stage, and AstraZeneca sought to objectively justify its decision. The tribunal accepted that having a safe working environment where employees could behave in an acceptable way was a legitimate aim for this purpose, but found that the company's actions in dismissing Dr. Muir were not proportionate. They could have intervened, they could have made a referral to occupational health and taken steps to help him and manage his behaviours at work. The tribunal also said that the employer could have taken steps to help him manage his stress at work, and these would have been less discriminatory alternatives to moving straight to dismissal. Dr. Muir also succeeded in his unfair dismissal claim because the company had failed to properly investigate matters, in particular the impact of his mental health on his behaviours. So the takeaway here is that you do really need to bottom out whether an employee's difficult behaviour or difficult working relationships arise out of a disability. And where you know that there's a medical condition, that will probably require you obtaining medical evidence. If you get that medical evidence and it establishes that it might impact the individual's behaviour, you need to make some allowances for the condition when judging an individual's performance or behaviour and consider whether there are reasonable adjustments that you could make to help them. So our third red flag, did the relationship breakdown arise as a result of bullying of the employee by colleagues? And I think this is an issue that really should be explored during the investigation process. And if an investigation fails to spot the issue, or perhaps spots it, but the employer moves on to dismiss the victim anyway, that may well lead to a finding of unfair dismissal. In that scenario, although the relationship breakdown would be potentially the fair reason for dismissal, I think there's a very significant risk that a tribunal would say the employer hadn't acted reasonably in all the circumstances by failing to investigate matters properly or by sanctioning a victim instead of perpetrator in that moment. Depending on the circumstances, other claims could easily arise too here. So I think the issue of discrimination may well be alive, as well as potentially the risk of a personal injury claim. Okay, so now we've been through those red flags and kind of the sort of stop moment. Theo's now going to take us through thoughts on process to adopt in this type of SOSR relationship breakdown type dismissal.
Thank you, Polly. So when will dismissal for relationship breakdown be reasonable in all of the circumstances? Importantly, this includes a consideration of whether the employer has followed a fair procedure prior to dismissal. What does this mean? For certain types of dismissals, employers must comply with the ECAS Code of Practice on disciplinary and grievance procedures. If they do not, the tribunal may uplift relevant compensation by up to 25%. Therefore, it's important for employers to get this right. The code is silent on whether it applies to SOSR dismissals, which has led to some uncertainty about whether the dismissal process must meet the minimum standards in the code. Case law suggests that elements of the code are capable of being and should be applied to some other substantial reason dismissals. However, it is likely that a sanction would not apply, as if Parliament had intended there to be one, it would have been made clear in the legislation. In my view, it'd be sensible for employers to observe the code's requirements where there is an overlap between the relationship breakdown and misconduct. This is because the tribunal may follow the approach in the scenario that the code applies if the employee is in some way capable for the breakdown. If the tribunal finds that conduct is the real reason for dismissal, then the result may be that the dismissal is held to be procedurally unfair, and any compensation may be subject to an uplift if they do not follow the code. Moving on. Even if the code principles do not apply to an SOSR dismissal, it must still be procedurally fair. Save in exceptional circumstances, that means certain core principles of fairness will apply, which in reality are pretty similar to the code principles. Although the precise nature of the process will vary from case to case, an employer will ordinarily be expected to follow the process set out on the slide. So the employer should carry out an investigation and should back up allegations regarding relationship breakdowns with facts. Relying on vague complaints and generalizations will not be good enough. Further, as discussed, an investigation is also vital to uncover any red flag issues. They should notify the employee of the allegations and warn of the possibility of dismissal. This is of particular importance where the employee is not aware that the relationship has broken down and this could result in dismissal. They should hold a meeting where the employee can make representations, and the employer should consider alternatives to dismissal. So employers will usually be expected to take steps to resolve the relationship breakdown without resorting to dismissal. And this could include things like offering workplace mediation, redeploying one of the clashing parties, or changing work patterns so that the clashing parties do not have to work together. They should consider other relevant factors, and this includes things like length of service, disciplinary record, consistency of approach, and the impact on the employee of losing their job. The employee should be notified of the decision in writing and offered the right of appeal. And an appeal hearing should be held if necessary, and the final decision notified to the employee in writing. Exceptionally, a relationship breakdown may be so serious as to make some or even all of the usual dismissal process futile. A case from just last month involved an employer which went to great pains to seek to accommodate an employee's preferences and provide choices, such as remaining in the same team or moving teams. The employee was confrontational and refused to make a choice between the options presented to him, even when a new role was created specifically for him. The employer persistently tried to find a solution, and all were rejected by the employee, and ultimately there was no choice but to dismiss. The extreme nature of this case and that it did not matter that no formal procedure was followed, and it was decided that issuing a warning would have been futile. So the key takeaway here is always take advice on that before you effect a dismissal. And I'll now pass back to Polly, who will conclude.
Thanks, Theo. So I hope today that we have kind of identified for you that relying on SOSR in a relationship breakdown, personality clash type scenario is a potential pathway for you. Nevertheless, what we can say for certain is, unfortunately, there's no sort of fail-safe way to achieving a fair dismissal in this scenario. I think the reason for that is because SOSR, by its very nature, is nebulous. That's because it reflects a kind of catch-all scenario. That means the nature of the dismissal process is going to need to turn on the particular facts of the case each time. That said, there are some important practical tips that I think we can draw out, and we've tried to do that for you here on the slide. And what these try to do is to put you as the employer in the best possible position. So firstly, ensuring that investigating and dismissing officers have been properly trained on the scope of their role. We've kind of talked about the importance of the decision making and how they might be scrutinised on that. And it's really important that they understand that. Investigation is going to be key. Has the relationship really become intolerable? What is the supporting evidence for that? And I would suggest that where you have a situation where a more junior employee is facing a sanction, you need to be prepared for a higher degree of scrutiny and investigation. Think about those red flags we talked about. If any of them are even kind of remotely in the mix, take some advice, because things can escalate if those are in play. Assuming that there are no red flags, you're going to be thinking about and identifying whether there are overlapping reasons for the proposed dismissal. So, for example, does misconduct apply here? And does it give you a more sort of straightforward path through a process? If so, be prepared to perhaps pursue that process or at least plead alternative reasons for dismissal where that's relevant. In third-party cases, you're going to want to ensure that you've got clear and documented evidence of the third party's instruction, the potential negative consequences, and where you may have taken steps to try to persuade them to change its mind. As with all dismissals, and you'll be very familiar with this, it's going to be really important to ensure that a fair process is followed prior to dismissal. That's the case unless you are extremely confident that you could demonstrate that it would be futile, but I would suggest that's pretty rare. As part of that process, you should be considering viable alternatives to dismissal and whether that's appropriate. And finally, in terms of that process, you're going to want to, I would suggest, benchmark it against the ACAS code to ensure against a compensation uplift if you were to be sued and if you were to lose. So that brings us to the end of our sort of prepared bit of this webinar today. Do hope you found it useful. On the slide here, you'll see our contact details. Please do feel free to get in touch with us in connection with anything we've discussed today.